step right into another amazing show. And trust me, you will adore today's show. Yes, you. Auntie Miracle B is live on YouTube right now.
Live in the booth, and then working. Big bro. You know what he do.
Good afternoon, good morning, good evening, wherever you are. How's everybody doing? This is one of Mr. Brooks's videos. It's a wonderful channel that's got all of his stupid videos posted. I mean, it's only like 4, but I just wanted to highlight this face, this punchable face. Let me go back a little bit. Oh, he is so unattractive. Ugh. I hate him. Oh, that's a good one. That's a good one. Have you ever heard of Dunning-Kruger effect? That's Dunning, Kruger, like Freddy Krueger effect. And that's a phenomenon that occurs when a person's lack of knowledge and skills in a certain area cause them to overestimate their own competence. This is the poster person for Dunning-Kruger effect. So today I'm going to go into day 1 of the trial, and I'm just going to hit the highlights or the lowlights, as I like to call it, and see these junky stunts that Mr. Brooks, who is you, has been pulling. Please make sure that you hit the like. Please like, share, and subscribe. I've been getting a whole lot of new comments on my video, and I am so happy to have you guys and engage with you guys. But please hit that like, share, subscribe, and your notification button. It really does help. All right. Well, with no further ado, let me get on to this idiot. Day 1 of trial. And of course, I'm going to also go into some of his sovereign citizen arguments. And I'm telling you, I found a new website. It is freaking awesome. It's going to be a lot of stuff that I'm going to try to explain, but I know I'm not going to be able to. But I'm going to post a link in the chat. So if anyone wants to check out this website, be my guest. I hope that you have some time and a couple of glasses of wine in order to get through it, because it is a bunch of nonsense. But with no further ado, one more thing before I get started. I just wanted to also say that this is a channel for commentary. This is commentary, and this is also satire. So even though I definitely was on the let this ass clown go to jail for the rest of his life, and I was rejoicing when he got all 76 charges, I am going to laugh at his expense. So I just want to just put that out there. Not that I'm trying to, uh, you know, minimize the suffering of all the 6 people he murdered and the dozens of people that he injured. I'm just going to make fun of him for being an idiot. And that's pretty much where I am with that. I just wanted to put that out there. Okay, so let's get to the beginning of day one. So you see him going back and forth, back and forth, back and forth. I don't know how many people are went to grew up in church. Say, you know, and I'm telling this to you from a Black Southern perspective. Okay, when you were forced to go to church when you was young, you used to hear the same crap week after week. You know that you're going to hell. You ain't living right. You got to get right, or you're gonna get left. And you hear the same crap week after week, and you are in church trying to sit still because your grandmama is going to pinch you in the arm, and you are staring at the dollar that you're about to put in the collection plate. You're playing hangman on a little piece of paper. You're just doing whatever you can to not embarrass your mom and your grandmama. Well, that's sort of like what he's doing now. He's the little kid who's restless in church, and he's staring at little things on his desk. Granted, he's not reading any of the documents that he needs to read in order to, get out of this. But he's staring at something, probably that same page out the Bible that, he never moved the page and his eyes never moved to indicate that he was reading. But let's continue.
All right, good morning, everyone. The court will call State of Wisconsin versus Darrell Brooks, case number 21 CF 1848.
Thank you, Charlotte. Hold on.
Reflect that the state of
Thank you, Charlotte, and welcome. I appreciate everybody. Kayla, James, Bright. I know you popped in. You may be gone, and everybody in my bushes. I appreciate you guys for coming out. Thank you so much. I appreciate it.
Here's this morning by District Attorney Sue Opper, Deputy District Attorney Leslie Basie, Assistant District Attorney Zach Wichow, and the defendant Darrell Brooks appears in person in custody. Also like the record to reflect that he is appearing in jail attire today.
That's going to be his permanent attire.
Mask.
And would like the opportunity to state that I'm here concerning this matter as third-party intervener in this matter, appearing as authorized representative for my client. I accept for value in return for value all the charging instruments in this matter and make my exemption available for discharge of all obligations and charges connected with this case. I do not dispute any of the facts in the charging instruments and would like to now reserve my rights if I may.
Okay, so this nonsense that he says on a daily basis, I'm a third-party intervener and I want to reserve my rights. Hey Mega, you're definitely going to get a headache reading that website. I'm telling you. So he gives this statement every day that he's a third-party intervener, and he does not represent, or what was we saying? He does not identify by that name, Darrell or Darrell, whatever his name is, Brooks. And so he's talking about charging instruments and all that stuff. So according to the website that I posted, hey Monica, that I posted, this is what a charging instrument is according to soft hard logic. A charging instrument, quotation marks, presentment is an offer, an obligation created on the public side by inventing a new borrowing against the creditor. On the private side, your straw man is offered the opportunity to assume the obligation. And what we must understand is that any presentment is a concocted debt. I can't even talk. Any presentment is a concocted debt on the public side created by the party responsible for issuing the presentment. Whenever you, i.e., your straw man, receive a presentment through your acceptance in return for value of the presentment, you can perform a legal commercial jujitsu by diverting the force of the presentment back to the issuer. So when he says, I accept for value in return for value, he's trying to do what it just said, perform a legal commercial jujitsu by diverting the force of the presentment back to the issuer. Does any of this make sense? No. However, yes, it's legal law, Joey. Yes, it's legal law. It's lawful law. So any presentment can be discharged by providing the offer with the charging instrument accepted in return for value and utilizing your exemption as a source of credit for discharging the obligation. Again, none of this makes sense. So please don't ask me to make this make sense. I ain't never heard of no stuff like this. I'm confused. I'm confused rated. It don't make no sense to me. Okay. But here's the main point here. If the offerer does not honor your acceptance in return for value, then he is the one in dishonor and can be made the party obligated to pay you for cost, fees, and damages on the basis of his dishonor. So I can kind of break that one down. So if Judge Jenny, and that's what I call Judge Jenny, if Judge Jenny does not honor that acceptance in return for value, because she always everybody ignores him when he says that, then Judge Jenny and the prosecutors and everybody else is in dishonor and can be made to pay him for costs, fees, and damages. So I don't know how that will work with killing 6 people, but whatever. Yeah, but let's continue. Did he beat? Oh, he beat the case in his mind. It's in his mind. He beat it.
Mr. Brooks, you just interrupted me within a minute of us starting this case.
What's
here
up,
today.
stuff?
I'm asking you to respectfully not interrupt me. That's the second time, so I can go through the list of things that I need to get through this morning.
I just wanted it stated for the record that
Mr.
I'm not
Brooks,
identified by
it
the name
wasn't
that
the
you called me
proper
by, that's
time to
all.
do that. That's now the third interruption. So,
With all due respect, Your Honor, every
Mr.
time
Brooks,
we,
by
every time
saying
we,
all due respect doesn't change the fact that you're interrupting me. Your objection is noted, all right? But you need to stop interrupting me so I can get through what needs to be done.
but it is
I
my
have a
right
number
to-
of documents
it is
that I
my
need
right
to discuss
it
this
is my
morning.
right to-
Mr. Brooks, you do not have a right to interrupt the court.
No, it
I
was-
will
that
remind
was
you
not
once
my
again
intention.
of the Supreme Court rule. It's on a yellow laminated.
How in the world is it not your intention and you keep interrupting her? I don't get it. I don't get it. Oh, he makes me so angry. He makes me so mad.
Double-sided piece of paper that is before you. I
do not
checked, I
recognize
verified,
that,
it
I
is,
accept it in return
Mr.
for
Brooks,
value,
that's
Your
yet
Honor.
another interruption.
Okay, and another thing with accepting in return for value. According to that website, Educated in Law, when you accept an offer and return it for value in your real sovereign capacity as creditor, you have accord and satisfaction. Lord have mercy. Really? Accord and satisfaction? Oh, wow. The fact is your autograph. Huh? That's a sentence. The fact is your autograph. You, as the real being, are a lawful man capable of of bearing a bond. You possess in rectus in curiae, meaning right in court, or standi in judicio, Jesus Christ, meaning standing in law. That means that you are capable of bearing a note. Only a lawful man can do that. So the lawful man puts his autograph on the line, establishing the fact. Private men and women use autographs, self-generated marks. Public side employees use signatures, signs of their juristic persona. Jesus Christ. Jesus Christ. Wow. This is weird to me because they are using a bastardized version of contract law. Wow. And contract law is civil. Woo, child. Let me get on with this.
Let me get through this, please.
I just want, for the
You will
record,
have an opportunity when I
I'll-
give you an
I want
opportunity. No
to
one
state
else
it.
is speaking at the moment but me. You need to stop interrupting.
I don't identify by that name.
Mr. Brooks, I am going to keep going. You are warned. You need to follow the standards of courtesy and decorum for the courts of Wisconsin. Chapter 62, that's another interruption.
I intend to follow decorum.
This court comes with a history of Mr. Brooks interrupting now. This is day 4, and every day Mr. Brooks has interrupted. It has resulted in Mr. Brooks being placed in a neighboring courtroom so that this court can efficiently, effectively, and with dignity preside over this case here today. I am well aware that's another interruption. I'm well aware. Stop
respectfully, which I
talking.
have the right to do.
I'm well aware,
And
Mr. Brooks,
I
that
have
you
not
object to the
intended
name
cause
that
any,
has
disruption.
identified on the information and all documents
just
in
wanted
this
noted
case.
for the
Your
record that I did
objection is
not
noted. It
identify
does
by
not
that
need to be
name.
repeated. I will make a record right now. The
May I
court
have the
notes
opportunity to
a
preserve my
continuing
rights, Your
objection
Honor?
by Mr. Brooks of his name and that he objects to being here. I know he's filed a number of documents previously
I never
related
objected
to
to
that.
being
Those
here. I just
documents
state-
are
I
of
tried to
record.
state
There's
that
another
for the record,
document
Your
that's
Honor.
filed. At least 2 more interruptions just now. I believe I'm up to 8. Mr. Brooks, you're advised that continued interruptions will result in you forfeiting your right to be present in this courtroom, where you'll be taken to the courtroom next door to appear by video and audio.
I don't
So, hey, one thing I wanted to notate. This is day 1 of the trial, and you see how the judge's hair is nice and coiffed and blown out, and she's calm and doesn't seem to be totally bothered. By the time we get to day, what is it, 14? It's like she's just said no fucks given, and she just came in. Hair was damp. She was barely holding on. She had to get her coffee. She was struggling, and it was like the struggle is real in real time. Ooh, I just think that was interesting at how she just devolved in front of our eyes. Okay.
Means to
consent being
participate
removed from the courtroom, Your
in,
Honor.
that's another
And you
interruption.
haven't shown me any lawful case law that I can be removed.
That is a good point, Stuff. This is how racists are made. And I do want to put on the record, I know y'all that used to hearing on the record, that the black delegation hereby revokes Darrell Brooks's black card for all time and in perpetuity. He is hereby revoked. We don't claim him. Why would we claim? You know what I hate? I hate freaking 40-year-olds who think that they're still going to be rappers. These are the people I hate. If you hadn't made it by now, it's not going to happen. And that just irks my soul. That just irks my spirit.
Moved from the
Mr.
court
Brooks?
proceedings in a trial and forced under coercion and duress to appear in the trial that I am needed that I've tried to express that I have the right to
Mr.
be
Brooks, there's a
present for
proper manner in which you raise objections. You have not followed that proper procedure.
He
You
don't
are
know it.
unable or unwilling to abide by simple rules of civility.
you. You haven't
You
given me the
interrupt,
chance to
you don't wait for
state my
anyone to
claim.
finish, and it will result with you being removed from the courtroom.
I
So
respectfully
you are
object to that,
once
Your Honor.
again reminded of that.
I love how the disrespect that he's given, he's prefacing that with I respectfully, with all due respect, with all due respect. That's just like when you hear, I'm not a racist, but I don't want to say anything racist, but, and you already know it's going to be something racist. It's going to be the next sentence. So, anyway, let's continue.
Going to give a little slack at the moment only because we are not in the presence of the jury. I'd like to go through a couple of things, the first of which is the jail attire. Mr. Brooks, we, meaning myself and the jail, have made arrangements by allowing folks to bring in street clothing for you. You've appeared previously in a suit and tie, very appropriate for a trial. If you no longer have those clothes available, jail has a supply of clothes that they can also lend to an inmate. The reason we make those arrangements during trial, sir, is because this court has taken a number of steps to shield from this jury that you are in custody. Your hands are not shackled. Okay, there are skirts
My
around
feet are
each
shackled.
one of the tables. I'm aware of the feet
Good.
shackles. That's yet another interruption.
Look, I thought that he didn't have I thought he had on shock devices. And I'm watching the trial yelling every day, shock him, shock that bastard, shock this ass clown. I mean, if he had on shock devices, I couldn't have been a deputy in that courtroom. I would have been hitting the buzzer. It'd just be like, eh. He would be fried. He would be so quiet and compliant. I would get him just the way I want him, nice and tenderized, and he'd just be sitting there. He could be a vegetable if I had the button. I mean, I wish they could have muzzled him. That would have been freaking awesome.
I'm aware of the shackles on your feet, and that's why the skirts are on your table and frankly, all of the tables, right? So that it appears to be the same for anyone coming in and viewing. Again, their arrangements have been made for you to appear in street clothes or civilian clothes. I would like you to appear in street clothes. And the reason why, sir, is to reduce or even eliminate even the appearance that you are in custody. And it is your choice, though. Are you willing to go back to your cell and put on your suit?
It is my right to do so or to not do so. And at this point, Your Honor, who doesn't know that I'm in custody?
Mr.
Who
Brooks,
doesn't know that?
I've had many trials.
Bruh, you're stupid. You know, a lot of people talk about how certain defendants will be in street clothes, like serial killers, like Jeffrey Dahmer or whatever. And then you'll have other people who are in jail attire. Or remember, OJ Simpson was in his street clothes, and a lot of people were upset because um, he was he in custody? I can't even remember. It's so long ago. But the fact that he was able to wear his clothes and it would made him look less of a murdering bastard himself. But my point that I'm trying to make is the attorneys always try to get the defendant to put on regular clothes to make them more human looking. If you're already in jail clothes, your little jail orange jumpsuit, well, the jury is going to see you and already have in their mind, well, this motherfucker belong here. You know what I'm saying? So that's why they ask, and you know they admonish their clients to put on regular clothes and to look human. But this is a fool for a client, like I said. Dunning Kruger,
trials with individuals who were in custody. And when I've talked to the jurors after the conclusion of the case, they had no idea. The whole point of allowing for street clothing is not only to shield jurors from the fact that you are in custody, but also you being in a suit and a tie or other street clothing, I think also lends to the dignity of the proceedings. This is a trial. Again, it is your choice. Are you willing to go back to your cell and be dressed in the street clothes that you previously appeared in?
With all due respect,
With all due respect, yeah, something disrespectful about to come out of his mouth.
I do not agree with that assessment whatsoever. There's no possible way that anybody will not know that I am in custody. I think that's a well-known fact because it's reported on every day in the media.
No, she didn't make him cry. He was well, he's did a couple of performances during like the testimony where the 8-year-old boy, the medical examiner was teared up about the boy being, nearly decapitated by this fool. He did a fake, oh, I need a moment. I need a moment. Ooh, ooh. And then he did a cry for himself, uh, bitch fest, when he gave his opening statement. Oh, woe is me, and uh, I've been called a monster, and I've been this and that, and this and that. The whole story hasn't been told. I'm gonna tell the whole story. And then he cried again in his closing. Did he? No. Oh yeah, in his closing, he cried in his closing. So he's done a lot of performances. This was all after the box fort. And this right here is going to be the box fort. These boxes of evidence that he didn't hadn't opened. It's going to be a fort to hide behind.
It's shown every day on the news where I am, what jail I'm housed in, and that I'm in custody. It's virtually impossible for anybody to not know that I'm in custody.
Mr. Brooks, did you hear the question that I asked you?
Hey, Average Joe.
And I respectfully keep the position that I just put on the record.
On the record.
Mr. Brooks, I will ask you again. Are you willing to go back to your cell or into the jail and put on street
I
clothes?
do not consent
Ugh.
or agree to anything that you just stated, Your Honor.
Of course not.
All right, he did not provide an answer to a very direct question. Let the record be very clear that Mr. Brooks was given multiple opportunities to answer that question. And go back, Mr. Brooks, that's yet another interruption. I will advise you, sir, that at any point in time, if you wish to put street clothes on, I would give you that opportunity to do so. You've already heard it is my preference. You've already heard me advise you regarding the steps that have been taken to shield the fact that you are in custody from the jurors. You refuse to answer my question about whether you would go back to the jail. That's another interruption.
Oh, what an ass
So
clown.
based on his refusal and his choice to come, that's another interruption. Based upon his failure to answer my question directly, I will take that as a non-response, but he came to court here today. That's another interruption.
I feel sorry for the court reporter who has to put this on the record. I feel so sorry for her having to try to make sense of this. I feel so sorry for her. Like, everybody in this courtroom deserves raises. They deserve a month off to recover. Like, we need to send them all some Ace of Spades, some Louis 13, some crudité, scallops and shrimp and lobster. We need to send all of that to them. Get Chef Ramsay to come and cook them a gourmet Michelin star meal. They need all of that for this. This was hell.
I will take that because he's come to court here today in his jail attire, that is a choice that he has made freely, voluntarily, and intelligently. No one has forced him to come
I
to
did not
jail in
consent to
those
that.
clothes. This court is encouraging him not to. He's appeared previously in his street clothes in what I would describe as a very nice suit and tie, but it is his choice to not do that, and we will proceed accordingly.
So while we're on the record, may I challenge the subject matter jurisdiction?
No, you
of
may
the
not,
court?
sir. You need to file a motion in order to do that.
So
Mr.
the
Brooks?
motions I filed haven't even been responded to. I gave.
Mr. Brooks, you're interrupting me
No,
yet
you
again.
just weren't speaking.
All right,
so I didn't
Mr.
interrupt.
Brooks, you are now going to be removed to the
I
other
don't
courtroom.
consent to that.
I have
I'm
had
under
a
duress
dozen or
by having
more interruptions.
I
We'll
have
be
shock-
off the record while we
Shocks on
do
my
that.
ankles.
Shock him.
I don't agree to a stop. Well, I move for a motion to dismiss for being under duress and being coerced into a contract that I not consent or agree to. I do not.
Yeah, there's no such thing as a motion to dismiss for being coerced. So, yes, under duress, yes. So, this ass clown gets put in time out. And so let me get to where he's in time out. Let me try and find. Yes, here we go. So, little baby cocker pants decides to take a shirt off in court. So he's in an adjacent courtroom. He is hooked up to, audio and video, so he can look at um, the proceedings and participate via his headset here. And here's the screen, and he can participate. Just like we're having, during COVID, and we had Zoom and WebEx meetings. He's got the capacity here.
Only individual in there. This court has, in essence, extended this courtroom to the neighboring courtroom. While there is ample evidence in the record, not only through the proceedings up to this point, but this morning alone,
Let's see
that
here.
through his conduct, he has forfeited his right to be present. I'd also make a finding that he is appearing from that courtroom, and that because of the audio and visual equipment and system that we have in place, that it is the functional equivalent of being present in this courtroom. This court has relied repeatedly on Illinois versus Allen. I've read portions of that case into the record. I don't.
Can you imagine how stinky it must be in that courtroom? Has anybody ever been in a jail before? Back in the day, I used to do probation, and I had to sign people up in jail. Oh my God, I'm talking about they will singe your soul. I mean, that I was like, Jesus Christ, y'all don't take bath? Like, oh my God, jail is a whole different place. And then these dudes had the nerve to try to ask me for my phone number. Bruh, no.
Intend to go through that at length here today, other than to indicate that trial judges that are confronted with disruptive, contemptuous, stubbornly defiant defendants must be given sufficient discretion to meet the circumstances.
So as you see, he's not listening. He is bitching to whomever's in the room, probably the bailiffs, and of course the bailiffs probably they're not interested in none of that shit. So yeah, they're not interested in hearing none of this. They just in the room, probably looking at him. So the case that she's talking about, Illinois v. Allen, she's always talking about how she's using that as precedent and how to handle a disruptive person. And so she's saying that, a person can be muzzled, they can be forcibly removed, or they can be put into an adjacent area and still be present electronically in audio, blah, blah, blah. Electronically, I'll just use that one. Electronically and participate in the proceedings. So she went with option C because he is representing himself as an attorney, as his own attorney. So he has to be present, right? So she moved him over there. But because he's stupid, You'll hear him later on in the trial talk about, you said there's 3 options, but you lost a 4th option, and that didn't have anything to do with muting somebody. Well, idiot, you're in the next courtroom. She's put you over there as the 3rd option instead of muzzling you and physically having you removed, and having the proceedings continue without him. She put you in another room so you could participate and gave you ample, talking about time and time and time again. Mr. Brooks, would you like to come back over? Mr. Brooks, I welcome you to come over. Mr. Brooks, I invite you to come over. And he complains about that because he would go off into the sovereign soft-hard nonsense, and she would mute him because he kept being disruptive. But let's continue.
Of each case.
Not
No
listening.
one formula exists for maintaining the appropriate courtroom atmosphere will be best in all situations. And in that case, there were at least 3 constitutionally permissible ways for a trial judge to handle a stubbornly defiant defendant, which this court would find Mr. Brooks squarely has become and has demonstrated over the course of these last few days. One option is to bind and gag him. I've already talked about at a previous hearing why I choose not to do that.
He needs to be.
Cite him for contempt. I choose not to do that either.
Shock
The
him.
3rd is to take him out of the courtroom until he promises to conduct himself properly.
And that's what she did the entire time. She'd be like, Mr. Brooks, I'll let you back in the room, but you have to conduct yourself in with our rules of decorum and procedure and politeness and protocol. She did it over and over and over. And a lot of people were very irritated with her because they thought that she was not forceful enough with him. And I do see how you could say that. But I think in her particular case, she had a lot of pressure on her because we were coming a year to the day of the tragedy. And so she wanted to get this plane landed in order to get this resolved and to make sure that he cannot try and get out on some technicality. But I do understand why people would say that she wasn't, forceful enough. Uh, and she gave him too many chances, but I think that she was just playing the long game, And women are good at that. We play the long game. How do you that we take your money, fellas? We play the long game. What free food can I get from you? Like I'm gonna start dating you in January or June. Hopefully I can build up enough equity in this relationship so I can get a free Christmas gift. Right? Oh, I may have passed up a good man. No, I not. No, ma'am. There was no stars in the jailhouse. No stars. I smelled booty hole. I smell funk and wagnalls, and I smell bad breath, concrete. And they use that cheap deodorant. I think they may even use Tussie. No, ma'am. No, ma'am. And this was not this wasn't federal, white collar crime prison. This was just municipal jail. This is the dumbasses who got caught stealing out of Claire's and out of Walmart. You got caught. Why did you even go into a store that is the size of a wall and mirrors are everywhere and you thought that you were going to get out? Please. No.
Mr. Brooks today, of course, showed up in court from the jail in his jail attire.
Of course.
He does that by his choice. I gave him the opportunity to go back to the jail to put on his suit and tie or other street clothes. He refused to answer that question. This court will continue with this trial, as I have previously indicated. There are many resources that have been put into bringing this day to bear.
Yep, we got you. So that's just her making a record that she just saying we are good white folks here, and we are not going to unfairly prejudice this black man who's incredibly guilty, but we gonna be as fair and make it as fair and overly fair as possible, so nobody can say nothing, nothing. So let's move on to Attorney Opper, who is she is my hero, my shero. I love Attorney Opper. And we said 49. And y'all make sure that y'all are hitting that like button, please. And thank you. Look at this, look at this clown.
That the record is very clear. I will note a continuing objection to the issues he raises regarding his name and other things. There are filings that's
I guarantee you stuff, if there was a black judge, like I don't know if you're familiar in the court sector, Judge Simpson and Judge Lanice Bryan, I think that's her name. This would be he would have grounds for mistrial in their court, especially Lanice. Or if anybody remember Judge Kim, technically he's Asian. Yeah, Judge Kim. It definitely would have been a mistrial with Judge Kim.
substantiate that. It will be my position. It's not needed for him to do that every single day because I've noted a continuing objection. With that, you want
Yes.
to make an additional record?
Sure would.
Yes, Your Honor, it's probably appropriate at this stage. I did want to address a topic that's maybe not been raised in the courtroom, but has been raised in the public, and it seems to kind of go hand in hand with the events of this morning, and that is the mental competency of Mr. Darrell Brooks to proceed to trial. The court is well aware that the district attorney has an obligation and a
Hey,
duty to
Sierra.
raise any concerns as to the competency of any defendant to proceed to trial. Any counsel representing Mr. Brooks would have that same obligation, and the court itself, if it had a concern as to the competency of any defendant to proceed, can request an evaluation that's pursuant to 971.14 of the Wisconsin statutes. At no time has anyone involved in this case had a competency concern. And I say that based on the fact that Mr. Brooks has made multiple court appearances, most of them before Your Honor, but at least initially he appeared before two court commissioners. He's had counsel representing him up until last week on this case. And
So basically, she's saying him trying to play this game that he doesn't know what's going on, that there's something wrong with him or whatever. Yes, this guy is definitely delusional. But she's saying that he is a regular in court. He knows the game. He's got charges from one end of the country to the next. And somebody in my comments said that he was pimping out Erica Patterson. Does anybody know if that's true? Because the story that he was going to get money from her, and she was holding his money. That seems sort of pimps up, holds downish to me. So I hadn't did any research because I've been on the sovereign citizen angle, and I haven't really did a whole bunch of background on him. But the way that the story sounds, he did admit on video? For real? Oh man, he was pimp. Oh. So anyway, well, there we go. Well, that's some hot tea right there. Well, there you have it. Okay, let's continue.
And you've made a record with Attorney Perry previously as to Mr. Brooks' ability to understand what's going on and his ability to participate in his own defense. You made a thorough record last week when you went through his waiver of right to an attorney. And
Those two videos, 1 and 2, that I posted, the colloquy where he proceeded to say he didn't understand what was going on, yet he wanted to be his own attorney. So it is on video. Okay. I'm about to find it. My God. That makes so much sense. The dynamic now. That makes so much sense.
And his absolute desire that he expressed multiple times to represent himself.
Hey, Vicky.
I would also add to
Oh, what's happening? I'm tired of this. What? What?
he is coherent, he is intelligent, he knows the issues in the courtroom. He discusses what happened in court that day with these individuals he's speaking to. I am thoroughly convinced, Your Honor, that Mr. Brooks is 100% competent to proceed to trial, that his mental capacity is not reduced in any fashion.
He's competent, like mentally competent, but he's stupid. Hey, Godmama, he's stupid. He's stupid as hell. The ex said it was money for his bail, maybe for his mama, because she be but he took her money even if she wasn't on the tracks during this incident. Gotcha.
Anybody that thinks otherwise has no involvement with this case.
Thank
Reference
you.
the court to today's filing,
Thank you, James.
which Mr. Brooks provided. It is extremely well written.
I
His
doubt it.
handwriting is immaculate. It's perfect. The punctuation, the grammar is 100% accurate.
Lies. That's a attorney. I would stop with the lies. You know he right the way he talk. Ain't no proper grammar and punctuation. Stop it.
He drafted this himself in his jail cell last night, I presume. Maybe it was this morning. He has continued with the same objections that he has making repeatedly in this case. So he clearly understands the issues. He understands the defense that he wants to pursue. He undertook the effort to have this form notarized.
Look, they probably telling him, look, man, like you need to chill with that bullshit, man. You need to stop with that stupid shit and listen on. You need to listen to what's going on, sir.
By a jail employee, so that it is a sign.
Yeah, look, you look like you stink. Here, put this hand sanitizer on and sanitize yourself. You need to take a what did Prince say? You need to clean yourself from the waters of Lake Minnetonka.
Sworn affidavit.
That's what he's telling them.
Absolutely no concerns on the part of the state of Wisconsin that Mr. Brooks has any deficiency in his competency. We are 100% convinced that these actions of Mr. Brooks are deliberate and intentional, and they have escalated. And the court has seen this since August 25th or so.
Baby, and it's gonna get worse.
As the motions were decided by the court, most of them to his detriment. His behavior became more and more difficult in the courtroom. It started out less aggressive with him sleeping and asking to be able to leave the courtroom. Then we had a toothache. Then we had a situation where he didn't want to come to court, was refusing to come to court. The record will be clear, Your Honor, that each time, and the Sheriff's Department has done an absolutely fantastic job dealing with Mr. Brooks fairly, professionally, respectfully at all times. We concur 100% with the record you just made as to what happened after the recess at about 8:42 this morning as to Mr. Brooks' conduct. These are deliberate actions on his part as we get closer and closer and closer to actually presenting this case to a jury, that he is attempting to derail these proceedings and avoid the inevitable.
Testify. Well.
And I want to make that record. I tell this court as an officer of the court, We have zero concerns as to the mental competency of Darrell Brooks to proceed. And we have had many, many dealings with him on the record and off the record that I base that on.
Go
I
ahead.
also wanted to add one other comment as to the court's record.
Go ahead, Opera.
As to the need to proceed with this trial. We concur 100%. We would also note it's not just a matter of resources. It's the need to proceed to justice. It's the need to get justice for the crime victims who have patiently attended every one of these hearings. They have a constitutional right to trial. They have a constitutional right to a speedy disposition of this case.
And they wanted to get this done before the 1-year anniversary. And that's what they was gonna do. He's talking to the I guess the bailiff, or probably to himself with the voices in his head. I don't know. All right. So Opera said this is a delay tactic because he knows that he is going to be in prison for about 1,000 years. So let's go to my next time stamp when Brooks is out of timeout. And he comes, well, before he's on timeout, he's asking a bunch of dumb questions. All right, hold on, let me get to the right thingy thing. Okay, that's close enough. We'll just do here.
I would add to the record some of the points Mr. Brooks made. Not only are these names all a matter of public record, the technology that we have at our fingertips, there's Google, there's social media. It's very easily to identify these individuals and search for them in other ways. I'd also add that there have been a number of news reports, media accounts, newspaper articles about victims, naming them. I'm aware of one such broadcast this morning on Channel 4. I cannot presume that all victims, all witnesses want this. And I want to keep this trial going, and that's what we will do. So the request is denied. All right, I believe, let me just get back to my first note that I had for this morning, that we've covered
And still won't sit down.
all of the outstanding issues.
If I may, I don't want to interrupt, but I did not hear if you, I was kind of overhearing that you addressed the filing that I filed this morning. I didn't hear exactly what was said.
Because you've been acting stupid all morning.
I'm just making sure that you know that I'm not trying to interrupt. I just want clarification on what I may have missed.
I'll tell you what I ruled previously. I've reviewed the filing. It's entitled Objection by Affidavit to the state's response and the court's opinion and order and defendant's disclosure statement by affidavit. It's an affidavit. It does not request any relief from the court. I have interpreted what you have filed as an objection to be noted on the record. It has been accepted, it has been filed, and that your objection is noted. The court.
So basically, when you are filing paperwork to the court, if you're filing a motion or something, you are stating your legal basis for what you're asking for, and then you have to ask for something. So if I want to file a motion to dismiss, I'm going to put, like the law, the code is a 12B6 motion, and it's a failure for the state of claim which relief can be granted. I would put in the brief or the motion what the prosecution failed to prove, and then ask for the motion to be, the case to be dismissed. But you have to ask for something. It has to be a legal basis, and then you have to ask. I'm asking for fees. I'm asking for damages. That you have to have that. You can't just have, I accept for value and return for value. I need a certified copy of your oath of office. your notice of waiver or protest, notice of acceptance. Okay, but you're not asking for anything. That's what she said. You have to ask for something. That's why it's noted on the record, but it's nothing. It's because you didn't ask for anything. Idiot.
Need not take any specific action as it relates to it. I further indicated that, again, no relief was requested, but also there's no statutory or constitutional or law that you cite to that I could even interpret as a request for relief.
See?
So that's how I'm going to address that filing, sir. It's noted for the record.
Can I say one thing about that?
Quickly, sir. I need to keep going.
I was filing that paperwork. I would say pursuant to the federal rules of criminal procedure under Rule 12.4
Oh.
about the disclosure statement.
Oh.
All right, I'll note
so I
that
will-
for the record, sir, but it was not in your filing.
Gotta be quicker than
So
that.
that's a judicial determination, Your Honor.
I believe I had one other thing.
I love that she
Oh,
ignores
I did
him.
want to put on the record, and that is when we were testing the audio, I did advise the sheriff's department to let Mr. Brooks know, to ask him on my behalf if he wanted to come back into this courtroom, standing as he declined.
No, that is not accurate, Your Honor.
Mr. Brooks,
The reason
Mr. Brooks,
I would just want to.
hold on, I'm gonna
For the
mute you
record.
for a second unless you
Shock
stop and
him.
listen to me.
Shock him.
I just heard what you said, but I just.
I'm
want
not
to correct
asking
the
for a
record because
response,
it's not-
sir. Mr. Brooks?
It's not. It's
Okay,
not accurate,
you're
Your Honor.
interrupting. Hold on.
Oh my
You're
gosh.
interrupting me, sir. I wasn't looking for a response.
What a douche.
I'm happy to ask you the question myself on the record for you to answer it. I will give you the opportunity to come back into this courtroom. You have demonstrated that you can make cogent, coherent, articulate arguments on
Lies.
the record. You just did that.
Lies.
You've been respectful for
Lies.
the time being. I will ask you, sir, do you want to come back into this courtroom? You've been unmuted to answer that question.
Here he goes.
Not until I can receive medical treatment for the bruise that I have on
Oh.
my and the cut. You just said a while ago on the record that you cannot see blood. That's because I wiped it on my pants, and you can
Oh.
still see the blood in the cut and a big bruise right here on my arm.
Oh
I was
damn.
told that the nurse would be coming in to see me, and then I was told no, she's gonna come at the next recess, which we just took. I know it was technical difficulties why you called the recess, but that was more than enough time for me to at least be seen, at least get the cut cleaned out and get it bandaged, at least at minimum that, and
Oh.
for somebody to look at this bruise.
Oh my God. Oh, we need someone to look at this bruise on my arm and this cut on my arm. Oh, but you killed 6 people, including a baby. You injured 60 something other people. He's covered in owies, y'all. Don't he sound like a elementary school student who is whining to the principal after they got into a fight? And you weren't the aggressor, so I'll let you go back to class. Well, I don't want to go back to class until I go to the nurse because I need a special Flintstones Band-Aid on my finger. I got an owie. This is a freaking blood. Whining like a bitch.
That was my position on why I was not yet ready to come back into the court, because I feel like this needs to be addressed.
All right, Mr. Brooks, I understand your request. I'm denying the request to take an adjournment, or I'm sorry, to take a break at this time.
No, I'm not asking for a break. I didn't ask for a break. I was just saying that at the time that there was the technical difficulty recess, before you even called that, Your Honor, I was told that a nurse was coming in at that time.
Okay, the
But then
nurse.
when you called the recess
Uh,
for the technical difficulty, I was
uh-huh.
then told that
Uh.
I would have to wait until another recess to be able to be seen by the nurse.
Okay.
Which my thing was, I
Mr.
wanted
Brooks,
to
you've
get
made
seen
your
by the
record,
nurse.
okay? I don't need you to go further with that. You've made your record. I'm gonna mute you for the time being.
She said nobody gives a rat's ass about nothing that you're talking about, sir. You killed 6 people. Deal. That's what she's saying. That's what she said to him, basically. That's what I would have said to him. Well, I probably wouldn't have said nobody gives a rat's ass, but I mean, I would have said, no one cares. You're gonna get a whole lot worse when you serve them 1,000 years. You're gonna be here. You're gonna be still in prison at the end of time. In the year 3000, you're gonna be still in jail.
I want you to be aware, sir, I was advised regarding the cut, the bruises, new information.
And he's still talking.
I made a determination that you would be seen at the next appropriate break. From my perspective, a small cut and a bruise is not going to hold up the start of bringing the jurors in and advising them of the preliminary jury instructions. If that means the next break we take is for lunch and that's when you are seen, then that's what will happen. So I don't think I've overlooked anything, Attorney Opper, but anything you had on your list?
Nothing else on my list, but I want to give Mr. Brooks one more opportunity to change out of his orange jail uniform, excuse me.
That I would give him an opportunity to do. Mr. Brooks, would you like to go back and change into your suit?
My position has not changed whatsoever, and it will not change, as it is my right to come into court how I would like to.
To my own detriment.
Just like I should be awarded the right to be present for every proceedings in this trial.
All right.
Bruh, you're present. You're talking to him. And if you act a fool, they have to do something with you. And they take you out of the courtroom because you are being disruptive. She's got to read literally 76 different jury instructions to the jury. And she's got to read all of the charges. That takes a big portion of this day. This is like an 8-hour stream. And it took like 7 hours to read everything. Girl, oh, he gets on my nerves.
I'm muting him again. I note your objection. I will take that as a clear indication you do not want to go back to the jail to change into street or civilian clothing.
But if he went back to the jail, he probably would have got his owie, kissed by someone if he had gone back. I don't know,
That you are exercising your right to dress in the jail attire. All right, then with that, I am going to just take a short recess just to have the jurors brought in.
All right, so we're gonna speed it along. Let me see.
Patient or tool.
Oh, okay, so she's reading jury instructions. So I'm skipping. There's like an hour and so I'm skipping. And so we're getting to so she's reading the jury instructions, and so he's in the courtroom, the adjacent courtroom, and he has an objection sign that he's holding up. I'm trying to see if I can get a shot of the objection sign. But this whole time he hasn't sat down, but he sign, and he even put the objection sign in his pants. I think I just saw it. Yeah, there you go, holding the objection sign.
Waukesha County, Wisconsin.
See, he got it in his pants. Objection. So she's just reading the charges. Now he's always saying he doesn't understand where he's being charged with the nature and cause of the complaint. It's not a complaint, it's a charge. But he doesn't understand. Well, she's reading it all to you and the jury, and you're not listening. But you have an objection sign stuck in your pants. Okay. Just wanted to show that. Let me just move on to. So while the judge is reading this, he's allowed to write out his objections and send them over to the judge, to the bailiff. And so when they get to a appropriate time, she's going to dismiss the jury and then allow Brooks to, she's going to address his filing. So that's where we're going to next. And that is freaking hilarious. So we're at 326:26. I'll just start here. So here she goes.
All right, thank you. Be seated. As I indicated prior to bringing the jury in, because of the process that was utilized for this court to approve of the jury instructions, and Mr. Brooks was provided with opportunities to object and provide input, I would not be taking a break or acknowledging, at least at that point on the record, any objection to those. Nonetheless, he held up his objection sign for much of the reading of the preliminary instructions. At 10:37 a.m., I received a note. I don't consent to that name. It is not me. It is not my name. Please let me object to this as it is my right. His objection is noted. I'm not going to take any further argument on that for the reasons I've already stated. At 10:48 a.m., he sent another note. Are you going to acknowledge my objection? What law are you citing when you cite intent? How do I know it's what the law actually says? I would once again refer Mr. Brooks to document number 244, the waiver of right to attorney form.
Uh-oh, this is important.
This court is under no obligation and in fact cannot give him legal advice and is not required to explain court procedures.
What's he objecting to now? She's answering his question.
Or the law. He was provided with a couple of different copies of the jury instructions. There was an original set, and then there was the set with the modifications. All of the instruction numbers are left in the jury instructions. There was a discussion on the record yesterday about access to jury instructions, even though this court is under no obligation, and explained that to him during the colloquy regarding the waiver of counsel, that I could not make any assurances about access to legal materials. I note he has his objection sign up. His objection is noted. But at this point, I'm still reading through these objections. I don't plan on having the parties make any additional comments regarding the jury, the preliminary jury instructions. Again, we had ample opportunity for that discussion prior to the court's approval. Mr. Brooks, I will once again advise you that you are welcome back into this courtroom should you wish, if you are able to conform your conduct to the rules of courtesy and decorum that you have been previously been advised about. Once again, direct your attention to SCR Chapter 62, Standards of Courtesy and Decorum for the Courts of Wisconsin. Would also direct you to Illinois versus Allen. That's the case I've been relying upon for the procedures that have been employed.
So let me tell you why he's objecting, okay? So these softards, according to the website that I posted earlier, theeducatedinlaw.org, says the crucial points to keep in mind in any court interaction are as follows. I'm not going to read everything, but the courts are equity, admiralty, probate, trust courts, not courts of law. Let me just repeat that one more time. The courts are equity, admiralty, probate, trust courts, not courts of law. In such courts, there is neither law, nor substance, nor facts, nor evidence, nor charges. There are assumptions, presumptions, color of law, color of substance, color of facts, color of evidence, and color of charges. Officials and attorneys execute the paperwork and pleadings as if your straw man is the trustee, or in parentheses, defendant, actually co-trustee of the public, mm, created by the 14th Amendment, with the duty and the state plaintiff is the beneficiary, i.e., co-beneficiary of the public, who has allegedly been deprived of his trust benefits by the delinquent trustee. Trustees are always outside common law. Again, that is a bunch of mumbo jumbo that makes no logical sense. Basically, what they are saying is that there's no criminal court. It's all civil, basically. That's what equity, probate, trust is all civil. It's not criminal. They said that even the word pay is a trap. Since there is no money but only debt currency derived from borrowing against the people, there's no way to pay a debt. So, hold on, let me get here. Let me move on from this public trust crap. Um, mm, 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 mm. Well, anyway, but that's sort of the base problem. Okay, so therefore, in any court case, the action is being brought by the allegedly offended beneficiary, the plaintiff. So, he's the alleged defendant. So, the court action is the alleged beneficiary, the plaintiff, as implied, or the co-beneficiary against defendant. So, the implied co-trustee. This is why the law and facts are all completely irrelevant. Y'all hear this? The law and facts are irrelevant. They sound like Trump supporters. If you go into court trying to argue either, you must necessarily lose, since the only issue is whether your straw man faithfully performed its duty as trustee of the trust, such as to obey the statutes, pay the taxes, or whatever else is required in accordance with the ever-increasing ocean of bylaws of the U.S. Incorporated. If you raise objections of law or facts, you not only traverse and dishonor, and that dishonor is arguing, and therefore automatically lose, but you give witness testimony against yourself that you are a bad, delinquent trustee trying to escape your duties as a co-trustee of the PCT. You see, none of this shit makes sense. It don't make no sense. This makes no sense at all. And the straw man theory is a pseudo-legal conspiracy theory. The theory holds that individual has two personas, one of flesh and blood, and the other a separate legal personality. So when he's always talking about, I don't respond to that name, his name is written in all caps on his birth certificate. Well, the all caps is the straw man, I believe. The all caps is the straw man. And the living, breathing human being, his name is written probably, the capital D and the capital B, and all the rest of the letters are lowercase. So that's his real flesh and blood person. Okay. So that's why he's always talking about, I don't respond to this name, because I guarantee the court caption, the caption of the case is written in all caps. So, yeah, I'm gonna just move on. Yeah, I'll just move on from this. Jesus.
Mr. Brooks is holding up the objection sign. I don't have anything in writing, which is the procedure that I told him he needed to follow in terms of me addressing any objections.
Hey, Andrea.
So if he wants to write down what his objection is, and we'll file that. We'll also indicate the time, if appropriate, after the break. But at this point,
I missed the part about the secret treasury account. The sovereigns say that the government uses the birth certificate to set up a secret treasury which it funds with an amount ranging from 600,000 to 20 million, depending on the sovereign belief system. So every newborn's rights are split between those held by the flesh and blood baby and the corporate shell account. So if y'all remember, like at the end, one of his last rants, he was talking about you just want to get access to um, that that secret treasury account or the secret corporate account. That's what he was referencing. Hey, Mayor. Oh, Paisley's right here laying on the floor, being a good boy. Now he's looking at me.
We'll be breaking for the noon hour, for the lunch hour. It's 12 noon.
Thank you, Debbie. Welcome.
Let's be back here at 1 p.m.
And could he also have the opportunity to change into his street clothes if he wants during the lunch break?
Absolutely. During the lunch break, I'm told, will be seen by jail medical staff for the concerns that
He gonna get his
raised.
owie
He'll be
fixed.
given the opportunity to change into his street clothing, should he choose. Of course, when he comes back once again. And
Yeah, blah, blah, blah. Okay, so they're breaking for lunch, and so he's going to come back. So let me speed this on along here to here. Oh, let's see, 4:43. This is where the magic starts. So she's inviting him back. He doesn't come back yet.
all right, then I'll have the jurors brought out momentarily. I just want to get confirmation from the bailiffs who are with Mr. Brooks that they offered, based on my direction, Mr. Brooks to come back over here. I don't know what his response was. Mr. Brooks, I'll ask you and advise you, you are welcome to come back to this courtroom. You've been conducting yourself in that courtroom, at least prior to the break, in a way that seemed to me that you were writing notes, perhaps even following along with the written jury instructions. I
He's
know
not.
you filed 2 objections. Those were addressed earlier. Mr. Brooks,
What is he
if you're
doing?
willing to,
What is he doing? It's like he's purposely just moving papers around just for GP. Like he just cannot sit still. Sit still, wiggle worm.
to abide by the rules of courtesy and decorum, you are welcome to come back. Would you like to come back to the main courtroom?
Can y'all hear me?
You're on the record. Would you like to come back to the main
Here
courtroom?
he goes.
And if I could just get confirmation from the bailiffs. I know the audio was tested. I was under the impression it was working.
You know you
Both
could
audio
hear
and visual.
these junkie stunts, man.
Do you know if anything what I said was picked up? Okay, thank you.
He heard every word you said, Judge Jenny. He literally heard everything.
Looks like Mr. Brooks has put on the headphones and they're testing them to see if they are working.
Please.
I don't believe he had those on prior to the break.
See, Judge Jenny was still giving him the benefit of the doubt. God bless her.
He had removed him at about 10:54 a.m. and when we broke for lunch, it was about 11:54. So it was about the last hour of the morning session. He was not wearing the headphones, Your Honor.
Thank you.
Opera watching. So you're not gonna
I
get
believe
by
those
on me.
headsets do need to be charged on occasion, so there are other headsets that can be provided
He don't need no
if that one is
headset.
not working.
Oh, I hate his. Oh, even with the mask on, I want to punch him.
Looks like a new battery pack, charger pack for that was provided. It's not the
Look, I
headset,
need
but the
attention.
attachment
I
that
need
gets
attention.
charged, so
I need
hopefully that
attention.
works.
Cater to me. I need attention. Look, I'm having
Mr.
fun.
Brooks?
Yes, I'm having fun.
I am offering you an opportunity to come back to the main courtroom. Would you like to do that?
Here you go.
I'm not sure why we're not hearing him very loud at the moment, but can you repeat that again?
He's not talking.
I see yes.
You'd like to come back? All right, we'll have you brought back then. Thank you. We'll be in.
All right, so he comes back. Let me speak this alone to where the magic happens. I don't say this before, but this is where the foolishness starts. Look at this. Oh, look at his face. Just. Can you imagine having this on top of you? Seeing this face on top of you? I got questions.
Mr. Brooks know that he certainly could take the opportunity during the lunch hour to put on street clothes.
All right, so we back in court.
So it's his choice.
He's still standing and twitching like Pookie.
He is here in the jail attire. He's at the table, continues to be masked. Welcome back, Mr. Brooks.
They never asked me during the break because I had so much other stuff going on. I'm not sure. I'm not saying it was intentional on their part, but I was never asked. I just want to make that clear for the record.
Who cares?
Thank you. I appreciate that clarification. Nonetheless, I provided you with that opportunity, and here you are. Please be mindful, sir, that the right to be here can, of course, be lost if you engage in disruptful, discourteous behavior, if you interrupt the decorum and do not show respect for the judicial proceedings. You would, of course, be subject to removal and forfeiting your right to be present in this courtroom. All right, I'd like to bring the jury out, Mr. Brooks. I am still going through the preliminary jury instructions. I know you filed some objections. Those have been noted for the record, as I advised earlier this morning. Because I've approved of them, there should be no objections. You had ample opportunity to do that. So I'm instructing you at this point not to object, because I will consider whether that's being done for disruption. If you have an objection, write it down on a piece of paper, pass it to the bailiff, and I'll take it up outside the presence of the jury.
Just so I'm clear, are we talking about objections to strictly jury instructions, or the filings that I filed on the 3rd?
I'm not addressing those at this point,
I
sir.
was just asking for clarification. I didn't know which one you were speaking on as far as the objections.
I'm talking about objections during
The
this
jury
court
instructions,
hearing
idiot.
to the court going through the preliminary jury instructions.
Okay, I was just asking for clarification.
Right. I'm not addressing any of those filings. I previously addressed those. It may not be to your satisfaction, but
Remember what you said, to be honest about that.
Because you weren't listening no way.
so the record speaks for itself. Your objections in those filings, to the extent, whatever they are noted. They're part of the record, and they will be available for you at a later point in time should you be convicted and on appeal to make whatever arguments that you need to or want to regarding those. But from my perspective, that is something I'm not going to take up any further. And any attempt by you to do that, I will have to consider whether that's being done to disrupt the proceedings and not for legitimate reasons.
It is.
The reason for bringing it up was to make sure that they are offered into evidence.
Sir, there's
Offered into evidence. Do you hear this? Offered into evidence. Reading preliminary jury instructions. And he wants these stupid sovereign citizen nutball theories and offered into evidence. How? How are we being? What evidence, sir? What evidence? Like what? What? I know any of y'all who have never been to any type of court proceeding, you know good and well that if they're just doing the very preliminaries before opening statements have started, there's no evidence being taken. Y'all all know this. It's just like he woke up one day, he had watched some Matlock in the jail or some Perry Mason, and he was just like, I could do this, I could do that. Just it just irks my spirit. This just really just irks my
We're
soul.
not at the evidentiary phase. They're part of the record. They've been received. So at this point, there's no evidence to be taken. We're not at that stage of the proceedings.
It's like
So
for
you will have an
and nobody's
opportunity
home.
after the state presents their case in chief and they rest to then present your case and to present evidence that's relevant to the issues before the court and the jury. So I'm not going to go through any further on what that means. That would be for me to provide you with an explanation of the law or procedure, but I expect you to not bring that up at this point in time or going forward.
And though, Your
Here
Honor,
he goes.
Mr. Brooks, I've already addressed them. I'm going to bring the jury out. Please do not disrupt as the jury comes in and as I complete reading the preliminary instructions. I am, just for reference for everyone, I've read through 44 pages of 69. And so I still have a ways to go. My intention would be to finish with the preliminary jury instructions, take a short break for all, including the jurors, and then come back with opening statements. And you have a choice, sir, at that point, whether you want to give one, but the state goes first because they obviously have the burden of proof. And then you would have an opportunity to give an opening statement as well. But that's my plan, at least for the afternoon.
I would like to go back over there, Your Honor.
You would like to, you're asking that to voluntarily be taken to that courtroom.
I'm trying to seek to understand how the testimony evidence that could be
Mr.
considered
Brooks, I've already
evidence.
dealt with that. I'm not going to deal with it. If you want to go to that courtroom, are you waiving your right to be present right now?
Can I at least raise the issue of subject matter jurisdiction? That's
No, there's no lawful motion before the court. You may not.
Are you making a judicial determination that I cannot?
Mr. Brooks, I'm going to bring the jury out. I'd like you to stay. That's my preference that you stay. You've certainly demonstrated throughout these proceedings that you have the capacity to follow the rules, that you have the intellect to make cogent, coherent, articulate, responsive arguments when you so choose. But when you start doing what you're starting to do right now, going back to filings I've already addressed, and start talking about subject matter jurisdiction, that is a tactic by you that I believe is to disrupt and to delay the proceedings.
That is not accurate, Your Honor.
Your objection to my characterization of that is noted.
I would like to make a motion for finding the fact then.
Your request is denied.
On what basis?
Your request is denied, sir.
Your Honor, I'm merely seeking to understand on what.
Mr. Brooks, I refer you once again to document 244 that you signed, that you acknowledged, dealing with the right to waiver of right to attorney. We went through all of the advantages, the disadvantages. You were advised of things, including the charges that you face,
and you said that it didn't shake you none.
Penalties that go along with them. We discussed the difficulty of representing yourself. You made a deliberate choice to waive your right to an attorney, which this court honored. and granted.
That is inaccurate
And
because
you,
I
Mr.
altered
Brooks,
the
don't
contract.
interrupt me. Okay, now that's at least the second time. So don't interrupt me. I'm going to continue with these proceedings. Even though you're mild-mannered, even though you're speaking in a soft tone of voice, the conduct still has the same effect. And that's to disrupt, to delay, and to show disrespect for the court proceedings.
It is not. It is not my
Mr.
intent.
Brooks,
It is not my
please,
intent.
I'm not
seeking-
going to force you to sit down. You're welcome to sit down, but I am instructing the jury to come out. You, at your peril, run the risk of me admonishing you in front of them at this point.
Well, he's already given so much. So many things have been at his peril, and he just said, whatever. So let's just continue on with it. Let's just burn it all down, torch it all.
I don't want to do that, sir.
I'm seeking to merely understand.
Sir, I cannot give you legal advice. I cannot give you the understanding that you want.
I'm
all
not
right?
asking for legal advice.
I cannot explain court procedures or the law to you. So with that, Mr. Brooks, that's another interruption. You keep going. Stop.
I'm seeking merely to understand, Your Honor. I don't understand the nature and cause of the charge.
Brooks, I've already dealt with these. Your
Bring up the subject matter
Mr. Brooks,
jurisdiction.
if you keep interrupting me, then you will forfeit your right to be present because you're showing through your conduct that you will not follow the most simplest rule of civility in a courtroom, and that's
Close
by
your
not interrupting. You
mouth.
continue to interrupt. It's been a couple of minutes since we've been on the record, and there's been a number of times you've already interrupted me. You claiming to not understand, and you want to discuss subject matter jurisdiction. Do not. It's just a tactic by you.
So what are
The
you
fact
gonna
that
say?
you are doing that demonstrates to me that you came back over here, right, with absolutely no intention of following the rules.
If that's what you want to say, that's your assessment. It's not accurate.
Well, my assessment will stand on the record, sir. It's based on my observations.
And
So
I
at this
respect-
point, Mr. Brooks,
I respectfully object
stop
to that.
interrupting me, please.
I merely
Stop
just seek to
interrupting me,
understand.
sir.
I'm not-
Understand.
I was
If
in the
you
middle
have
of
an
saying
objection, write it down.
I thought that applied to me being.
It's
from
applying right
another-
now since you keep
I-
interrupting me while
So
I'm talking.
what is the purpose of me being present if I'm not able to ask simple questions that I do not understand?
Oh God. Okay. It's not ax with the AXE. It's ask with the K. He drives me nuts when he says ax.
I'm
Mr.
just
Brooks,
seeking.
I've been
I'm not
more
asking for
than
legal
patient
advice.
with you. And the issues that you keep trying to raise every time we're in here are not issues I'm going to raise at this juncture or address at this juncture in the proceedings.
Is there
All
a
right,
reason
I've
why?
already, I'm not giving you advice.
There's a reason
I'm
why.
not explaining the law. I don't need to do any of that, sir. All right, you filed what you needed to file. I've addressed every single filing on the record. It may not be to your satisfaction,
That's
but
inaccurate.
I have addressed them.
That's
All right,
inaccurate, Your Honor.
some of your
With all
filings,
respect.
sir, you're interrupting me yet again.
With all
because
due
you're not
respect.
letting me finish with my explanation. Some of your filings do not require a specific line by line response by the court. I've addressed them in the way that I believe the law requires me to do. Again, that may not be to your satisfaction, and that is simply the way that it's going to be.
It doesn't
But
have
we are
anything-
continuing on with the reading of jury instructions. It's important. They're going to come in, and it will be up to you whether you can demonstrate respect and courtesy, not only for these proceedings, but for the jurors that have been selected to hear this case.
God bless this woman.
Madam Clerk, have the jurors brought
Your
in,
Honor,
please.
what you're doing is judicial misconduct. You're making the judicial determination that I'm not allowed to ask questions, that I'm not allowed to question Your Honor, which is my right. I've merely brought up subject matter jurisdiction because it has merit. I've merely try to seek to understand the proceedings that I do not understand.
But that, y'all, this makes no sense to me. How do you not understand? I, 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 let me just hit play. I'm just.
You're rushing me to judgment by constantly removing me from the court when I should be present for all proceedings,
You've been
and I
present.
should be able to understand, which I do not. Once again, I do not understand the charges, the nature of the charges against me. I do not understand.
How do you not understand the nature of the charges against you? You drove your car into a Christmas parade and killed people. I'm sorry, you drove your mother's car into the parade and killed people. I don't know why this is confusing to him.
And why Your Honor will not answer mere questions that would give me clarification on understanding. I'm not attempting purposely to be disruptive, disrespectful,
Right.
in any manner.
In any manner.
But if I don't understand something, it benefits me to ask so that I can have clarity. The waiver that you speak of with the attorney,
listen to this, y'all.
I gave the waiver back in the way that I felt that it should be altered.
So the waiver, he decided to alter it himself. Let's continue.
And you said so yourself on the record that the word understanding was taken off of that paperwork that I sent back to you. That should have let you know right there further that I did not understand the proceedings, and that was some of the issues that I'm bringing up now.
That's amazing. That is exactly not what happened. You were playing the sovereign citizen BS game, word game, and you don't want to put understand because that's according to you, a tacit agreement, and that you are giving you're giving the court jurisdiction. So you want to play games and say that you're aware. And so she asked you specifically if you understood, and you marked it out and said, I am aware. And she went over each section, and she asked you about the checkbox that you made. And you were saying that you wanted it to be, you filled out a certain way because you wanted to have assistance of counsel. And they told you to your face multiple times that there's no assistance of counsel. And they asked you specifically, did you want to waive your right to an attorney? You said yes. So how are we confused? You don't understand? And because you marked out understand, she's supposed to know that you seriously didn't understand, but you was playing games, saying that you didn't understand. Boy, bye, goodbye.
It's merely just clarification, Your Honor. I don't understand what is going on. It's not to be disrespectful. It is not
Mr. Brooks.
So I don't understand what's going on, but I insisted 3 days ago. I insisted 3 days ago that you allowed me to fire my attorney so I could represent myself. But I don't understand nothing that's going on. Nothing. I don't understand not shit. Not shit. But I asked for this. And now I'm the dog that bit the tire on the car, and I'm being spun around and thrown in the street, and now I'm complaining. Boy, stop. Junkie stunt, stop.
Prolong the proceedings.
Do you understand when I tell you not to interrupt me?
No,
do you
no,
understand when I tell you need to follow the rules of decorum? I believe you do. Please sit down. The jury's coming in.
I still would like to ask questions, Your Honor.
You
Stop
can't
talking.
ask questions,
We are
sir.
proceeding with the continued advisement to the jury of these preliminary jury instructions. Do not interrupt me. The record should reflect that the jurors are entering the courtroom.
Your Honor, with all due respect, I
Mr. Brooks,
still-
stop talking. It's not appropriate at this point in time. You'll have opportunity.
I disagree.
You know, he's one of those kind of guys that women, we're afraid of dating because they do not take no. These are the guys that try and talk to us in the club or out, and you try to be polite to them and tell them, that you're not interested, and they continue with either extra nonsense that you didn't ask for, or they start calling you a bitch. The same, hey, no means yes. And I'm just going to continue, even though I've been told no 1,001 times, that 1,002 times that means yes. No means no. But that one time, that means yes. So this lets me to believe him being a sex offender is appropriate. Because you do not take no for an answer. So yeah, you being a registered sex offender, not allowed to spend time with your children, all these kids that you were concerned about, that you're not allowed to see because you're a sex offender, and all this child support that you haven't paid because you're a sex offender. Yeah, that's probably why mama didn't let him in the house, because maybe the kids were there or came to visit. He can't come in the house. Or maybe the grandbaby was in the house, her grandbaby, her and his teenager, and he's a sex offender. He can't come in the house. That's why they was in the car, probably. I bet that's why they was in the car.
Later to raise other issues, but the issues that you seek to engage with this court are issues I've already addressed.
You have not. You have not.
Brooks,
You have
the
not
jury
shown-
is in the
I
courtroom.
understand that,
You
Your Honor.
continue to talk despite being told to sit down and to pay respect to this court, to these jurors, to the process.
It is my right to stand or to sit, Your Honor. It's my right.
Mr.
I'm
Brooks,
realizing
you can
my right.
stand, you need to be quiet.
Shut your face.
Thank
Your
you.
Honor, Your
Mr.
Honor.
Brooks? Please
Shut
stop. I'm going to continue with the instructions. If you interrupt me, you will run the risk of being taken to the courtroom next door.
I'm seeking an understanding, Your Honor.
Mr. Brooks, final warning.
I'm seeking an understanding, Your Honor. It must be some clarification.
Mr. Brooks, I want you here.
I want to be here.
Stop interrupting me.
You were quiet. I didn't.
Mr. Brooks, stop talking so I can read through the instructions.
Your Honor, cannot.
Ladies and gentlemen of
You
the
can-
jury,
you can
I'm going
move
to
me to the other
continue
team.
with the jury instructions.
All right. So she gone on about her business. Okay. Let me see. Let me see. That's right here. Okay. Let me move on to his next round of options, because she's reading and he's writing his little objection notes to the bailiff. Oh, this is what he's saying, that a jury flipped him off, which I don't believe that at all. She's still reading.
A number of pieces of paper that
Ugly
Mr.
face.
Brooks wrote on. I'm going to have them copied so the state can be aware of that and respond if necessary. So we'll just take a moment while those papers are copied.
I have that jacket.
I called them, but all right, we will follow.
Okay, so while all that's going on, I'll just read this part real quick. And part of on that website, here they're talking about strategies when you go to court. So this is and I just saw this and I thought I have to read this. Okay, so it says when your straw man's name is called or the judge asks you your name, you can say one of the following, whatever you're comfortable with. So tell me if you've heard this. I am here concerning that matter, or I am here as a third party intervener in that matter, appearing as authorized representative for my client. I bet you he got this crap from this website. Because you know he has access to the internet. Okay, so the 21, oh, wait a minute. Oh, the third party intervener is you, the living principal, acting in your own interest because you have a pre-existing claim against the defendant that precludes them from acting against any version of your all caps name based on your prior contract therewith, such as your UCC, specific power of attorney and indemnity and whole harmless agreement, your employer ID, etc. And then it says, then continue, I accept for value in return for value all the charging instruments in this matter and make my exemption available for discharge of all obligations and charges connected with this case. I don't dispute any of the facts in the charging instruments. Oh my gosh, I think I found the source of his shit. This website. Okay. We must not try to pay with public funds. We must not try to prove ourselves innocent, and we must not plead not guilty, which is arguing, traversing, dishonoring, and telling them that you are joining the imaginary game and treating it as if it were real. All attempts to do these things are traversing and dishonoring, breaking the law, and committing treason against the equity court by trying to deal with the dispute as if it were substantive, private, real, and in common law. Wow. Let me continue.
How many copies you making?
That's where this crap is coming from.
Yeah, okay. We'll make sure you have copies of the filings as well, so you know what will be discussed or at least addressed in some fashion. But I need to provide copies to the state.
Oh, okay. Interesting. Well, thank you, Charlotte.
Go ahead, sir.
I noticed that one of the jurors, the lady in the black that's closest to the screen in that corner chair over there, I recognize her from my initial appearance. She flipped me off coming in to my initial appearance and coming out.
The juror.
I know it's her for a fact. I seen her about like how I'm looking at you right now. So I know for a fact that's her. I don't want that to end up being an issue. Is this some type of way that can be addressed by Your Honor?
Mr. Brooks, you had an opportunity to exercise preemptory strikes and even to question jurors about that. You chose not to. So at this point, any issue you have with that juror is waived.
Okay. You do remember that I was not present in the courtroom.
Who fault is that?
I couldn't see. All I can see from that courtroom in there is just you, Your Honor, and the prosecution's table. I can't even see the bailiffs.
Boo-hoo. Well, maybe you need to moderate your behavior so your black ass can stay in the courtroom. You thought about that? No.
So it was no way for me to even see who the jury was. Obviously, I wouldn't know them by name. If I would have been able to see the jurors, I would have immediately addressed that.
He's so freaking stupid, man.
I will make this one indulgence. I'll have the civilian bailiff ask that juror if she was in attendance at your initial appearance out of an abundance of caution. These are jurors, though, who with the jury questionnaires were also asked what knowledge they had about proceedings they watched or even attended. And no one, to my knowledge, has disclosed anything like that, but out of an abundance of caution, we will ask that juror if she was in attendance at your initial appearance. So for now, that's how I'll address it. I'll advise you of what her answer is later.
That's the best she can do
Do you
for
know the number of the
you.
jurors, sir? They have numbers.
I just know that. I can't see the number from here. I just know the chair she was sitting in.
Judge Jenny, he don't know no numbers. You asking too much.
Which chair, sir? Top row or the
Bottom
top
row.
or the bottom row?
The bottom row,
Yeah.
the last black chair. Black shirt. She had the black
They're
shirt
all
on.
black chairs, sir. So
The last
chair
black
closest-
chair closest to the television.
Thank you, sir, because there are two sides, right? So it's the last chair on both sides. So I wanted to make clear. You're saying the chair closest to the television. Thank you.
Punch
I
him.
said that at the beginning, Your Honor.
Oh, shut
Front
up.
row. All right. State have copies of the filings.
Yes.
Okay, I think he's about to be acting up still.
I will take these in order.
Oh, yeah, okay.
First is a note from Mr. Brooks that was handed to Deputy Wittig at about 12:05. It says, "I would like my filings addressed. See notice of special appearance, statement of particulars, both are by affidavit filed 10/3/22, which today is deadline to respond. Thank you, Mr. Brooks. I'm respectfully declining to respond to those filings." That's my decision, sir.
There's just a
I'm
determination.
making a judicial determination that those have no merit.
Mr. Brooks, I have indicated to you on the record what I will or will not do.
I would like to motion for finding a fact.
Your request is denied. The next,
May Your Honor explain why. it
Mr.
is
Brooks,
denied.
I'm gonna go through these one by one. If I feel the need to make more of a record, I will do so. The record will be available later on. If you think I've made an error, you can then raise that on appeal.
I know you're making the error, Your Honor.
Mr.
You wanna
Brooks,
explain
I'm
to
not
me
gonna
why.
have a debate with you right now. We
I'm
are
not.
continuing on. I'm giving you the courtesy to respond to each one of these things. That's how I've responded. I expect that you will, even if you disagree with my decision, sir, that you will respect it and we'll move forward. Next piece of paper filed at 1:52
I still would like a
PM
judicial, are you making a
says,
judicial
are you making a
determination?
judicial determination? I'm not allow my right under the First Amendment to freedom of speech in this courtroom. Mr. Brooks, we have rules of decorum and courtesy. They have been provided to you multiple times. They are part of the materials that you have before you.
Do they fall under the First Amendment?
SCR Chapter 62 discusses just the standards of courtesy and decorum for the courts of Wisconsin. In addition, sir, parties are able to file requests with the court. It's called a motion. A motion, however, is based in law. There is a citation to not only that law, but relevant facts, and there's a request for relief. While you have the right to present a defense, you do not have a right to disrupt the proceedings.
That was not direct,
And
disruption.
Mr. Brooks,
I was asking, will my First Amendment right, which is freedom of speech and the right to be heard in court, will that be honored by Your Honor? That's a valid question.
Mr.
Because
Brooks,
that's a constitutional
I
right.
have given you ample opportunity to present information.
So you do have a constitutional right of freedom of speech. You absolutely do. However, you cannot run your mouth at any given time because there are still rules. You can say crazy, racist stuff online. You can be on caught on a cell phone, being drunk, calling everybody all type of names, doing all type of crazy stuff. But then your consequence is that you'll probably be publicly humiliated and you'll be publicly fired, and everybody will label you as a racist. So there are consequences to your freedom of speech. So you can say whatever the hell you want to say, but you still have to deal with the consequences. So, sir, yes, you have freedom of speech, but you cannot be heard by interrupting the court proceeding because there are rules and there are procedure, and you have to follow those, sir. Moron.
Evidence to question when we've had witnesses on the stand, but I expect you to follow the rules of procedure, the rules of evidence.
The rules of when you was in elementary school and they told you to be quiet and don't talk when other people are talking. That rule. You can cite that one.
Presenting your requests.
I can't even
So-
get these admitted into evidence.
Evidence.
That's Mr. Brooks. I cannot explain to you if you don't understand the basis in law for the
You're
denial.
right. I don't understand.
No.
But
So,
I was
but that
following-
doesn't mean we're going to have a
I was
discussion
following- no,
or a
I'm not
debate
trying to debate
about
with you,
what
but I
it
was
means, because we're
following-
not
I
going
was
to do
following
that.
the rules that you said.
So the bottom
by
line is, I
writing
don't
and
feel,
sending it.
Mr. Brooks, stop talking. I do
No,
not
I was
feel,
right. I was following the rules.
He said
You
no.
said that I had to make all
and you did, and I'm
objections
going through
in
them, so
writing.
let me, give me the courtesy of replying or responding to these. And please give me the courtesy that even when you disagree with how I answer them, that you will not interrupt me.
It's not about me trying to interrupt you, Your Honor.
Mr.
All I'm
Brooks,
saying is
I'm going to address the next one,
What
so
you-
please pay
what you
attention.
were saying about decorum. I was asking, does that fall under the First Amendment? Because the First
Oh, my
Amendment, which is
God.
my constitutional right, says that I have the right to freedom of speech and to be heard in this court.
Mr.
That's
Brooks,
all I'm really-
again, you have the right to present a defense, but that right is not
But that's under
that
the Sixth
right,
Amendment. I'm
Mr.
talking
Brooks,
about the First
you
Amendment.
are interrupting me. Stop.
Because you're talking about
No,
a-
because
you're
you're
talking about an
purposely
amendment that I'm
doing
not
this,
referring
so
to,
I
Your Honor.
can't get my reasoning
But
out.
I'm
You
not
make it
referring to the
incredibly
Sixth
difficult.
Amendment. I'm not referring to the Sixth Amendment. I'm
Mr.
referring
Brooks,
to the First Amendment, which clearly says that I have the right to freedom of speech and to be heard in the courtroom. Are you not going to honor my constitutional right, Your Honor? If not, that is judicial misconduct, and you're making a judicial determination to not honor my constitutional right. I just want to be treated fairly, like anyone else, which you said on the record that you will be fair and impartial. What
Mr.
you're
Brooks,
doing
you
is
also
not
have
fair
an
and impartial.
obligation to treat this court fairly, and you have an obligation to follow the rules of courtesy and decorum, the rules of procedure, the rules of evidence.
Your Honor, I did
That's
not-
the playing field that you willingly entered into and made a deliberate
did not.
decision to waive your right to an attorney
I
and
can-
to appear
I
in this
consented-
case
I
as your own
consented to
attorney.
represent myself pro per.
Ugh.
The same paperwork that you
Per.
gave me, you have, and I also have a copy of the same one where I scratched out what I did not agree or consent to. We both know that, Your Honor. All I'm
Mr. Brooks,
simply-
I made
all I'm-
findings regarding that, and those findings stand, that despite you scratching out some of those words on
But-
there, I
but
made
you-
very specific findings about your waiver of right to an attorney. So we're not going to relitigate
You
that
also,
shit right
also
now.
accepted the terms of the paperwork that I
Mr.
filed out.
Brooks, I'm not going to engage with you about whether you and I have entered into some type of a contract
We did
or
not.
engage in
we did
any
not.
type of
We
that
did not
kind of
enter into
dialogue,
any
because
contract.
that's what you're claiming through some
No,
of
I'm
these
not. I'm
filings, and
not
you've
claiming
said that
I
previously.
am not claiming that, Your Honor.
So,
In any way, shape,
Mr.
or
Brooks,
form, I do
I'm
not
giving you
consent to
some
any
leeway.
contract.
You continue to talk over me. It's, you please, I'm asking you to follow the rules of civility. Simple rule, sir. Don't interrupt me.
Did I not just let you read the whole jury instructions and follow the rules that you said I have to write down
You did,
anything that I object to and then hand it in?
except
I'm
now
just-
that we're discussing them, it seems to me that the rules don't quite matter to you.
He's just like my puppy. He is just like my puppy. I can get him to sit down and sit on his bed, but the second I get up and move somewhere and I tell him sit back down, he's still trying to follow me someplace else or attack my shoes. Or didn't I do the little trick that you told me to do earlier? So shouldn't that count? I can be able to say what I want to now.
Sir.
No, that is not what's
So,
being asserted.
Here's
on my
what's
end.
happening, sir.
All
I'm
I'm-
telling you,
all
I'm
I'm asking
advising
for-
you to respect the rules. I'm advising you that if you continue to interrupt, you risk your right to be present in this courtroom.
Are you
because I still need to continue with these proceedings, sir. I need to go through all of the documents that you filed, and you're not letting me do that.
Because we didn't
So
get
I'm
past
gonna,
the
if I
issue.
need to, I'll remove you to the other courtroom so that I can do
This
this.
is-
And yes, exercise the mute button, sir.
this-
Mute
this
him.
But,
is-
and
this
then
is
I'll bring
something
you
that was
back on the
filed, though.
jury's back.
This was filed though, Your Honor, and it's a valid.
Mr. Brooks is
it's valid.
clearly not following the simple rule of civility that I have established.
That's
He
inaccurate,
continues
Your
to
Honor.
interrupt. He's not
Kick his
providing this
ass
court
out.
with
Your Honor.
ability to make rulings on the record without interruption.
Kick
So
him
this
out.
is your final warning, or you will be removed to the other courtroom.
Will Your Honor honor my First Amendment right?
I'm
Or are
not
you
answering
making
that
it- or are
question,
you
sir,
making it
because
the-
I've already addressed
So
it.
you're making a judicial determination to deprive me of my constitutional
I am not
right.
making any such determination,
So
sir.
you just
Anything to try and force a mistrial. He's just saying all this stupid crap, so it'll be in the record, so he can say, "Look, she said that my First Amendment rights will not be validated." Uh, like, how are you going to tell people who have gone to school and a judge who deals with procedure and evidence and the Constitution? Well, yeah, kind of. The Constitution. How you gonna tell her that she's wrong? But you know. Let me hurry. I'm gonna get ready to finish this because I'm at the over the 2 hour mark.
said you're not going to answer the question about my First Amendment right, which says
Sir,
that
I've
I have
already
freedom of
answered the
speech.
question that you have a right to present a defense.
That is the
You have
Sixth
a right
Amendment,
to
not
be
the first.
present.
You're trying to twist
You
up the
have
amendment.
Twist
A
the
right
amendments.
to present your defense, but your rights are not unfettered.
Yes, they
Your
are, Your Honor.
rights-
You're citing the Sixth Amendment, which I am not
Mr. Brooks,
questioning.
your
I'm-
First Amendment in some respects is circumscribed by the rules of evidence and the rules of procedure.
Does it say that I have
So that
freedom
doesn't
of
mean you
speech?
get to say anything that you want in
No,
front of
I'm-
a jury.
Your
And
Honor,
it doesn't mean you get to put forth any kind of evidence that you want in
Your
front
Honor,
of a
am
jury.
I
What it
being-
means, sir,
am I
is
being
that
disrespectful?
you must
Am I
follow.
calling you
Yes,
out
you're
your
being
name?
Yes.
Am I threatening
disrespectful because
anybody?
you're
I'm
not.
not doing anything of the sort.
All right, he is continually talking over me. So at this point, I'm going to find that he's forfeit his right to be
I have
present as
not
I
forfeited
go
my right,
through
Your Honor. I have
his
not consented to any. I'm
his
simply trying to
paperwork. He's to be
understand
removed to the other courtroom
I'm
until
simply
such
trying to
time as he
understand
can pledge to
why we're
follow
not
the
talking
rules
about
of
the First
decorum and
Amendment. I'm not
civility.
talking about the
We'll be
Sixth
in
Amendment.
recess until we have
Your Honor,
everything
I do
set
not
up.
agree to a
The
estoppel.
record to reflect, I'm stepping off.
It's interesting to me how you're here shackled to a table and you're still talking about I do not consent to anything. I don't consent. I didn't agree to it. I don't consent. You can kiss that goodbye. Your custody. They tell you what to do and what to eat. He drives me nuts. I was gonna try and get through some more of his outbursts. It's so many, and then some of his cross-examination of some of the witnesses. You know, some of his sovereign citizen. Do you know the plaintiff? Have you ever seen the plaintiff? Have you ever had any interaction with the plaintiff? Do you see the plaintiff? You know, that stuff. So what I will do is I will do a part 4, and it'll be the tail end of day 1, and then I will go on to the next day, day 2. So yeah. Let me see here. Yeah, there we go. Yeah, so I will go into day 2. So I'll do another one. I may do one the part 4 of 4/part 2 of day 1. I don't know, maybe tomorrow or well, no, I'm getting my nails done tomorrow. Maybe Friday or Sunday, but it'll be before next week. And then next week I will do day 2. But anyway, I want to thank everyone who has come by, and thank you, James. Everybody has come by, all of the new people. Welcome, welcome. I hope to see you again. Please make sure that you like, share, and subscribe. And hit your notification button. Anyway, I am going to get ready to get my little tushy ready for bed so I can go to the gym in the morning and put this little puppy to bed. And I know y'all heard him barking. But anyway, you guys have a good night, and I will see you guys on the flip side.
Drums, please.
Ladies and gentlemen, we have had a great time tonight. We have truly enjoyed ourselves, and we would like to thank you for being a part of the show and coming to visit this platform. Live on YouTube, Auntie Miracle B. Make sure you come back, because it's all the way live each and every time. Auntie Miracle B.